Now it gives us a chance to check in one more time with Dimitri Gorin, who's been kind enough to spend some time with us here. Dimitri, let me ask you something before I ask you about Melissa Grosvenor and her sister. And that is what we've just been watching here, right? Testimony by Detective Richard Tomlin, who, whatever you may feel about whether Phil Spector is guilty or not guilty, I think you have to conclude that he was a very professional witness on that stand. I know if I was back in my prosecutor days, I would love to have all my witnesses be like he was. But it was sort of an interesting scenario in the courtroom because you have this witness being called by the defense as a defense witness, even though there was not certainly hostility there. As I said, I think Detective Tomlin was very professional. It's still a little bit awkward. Talk about how the rules change in terms of questioning and cross-examining when the defense calls a police officer to the stand.
Well, if a witness is deemed hostile by the court, or one of the lawyers asks for that basically name, the witness is now hostile, different rules apply. In other words, if you're calling a witness that's now been deemed a hostile witness, you can ask questions like you would do in a cross-examination, leading questions. I don't know if this detective was actually deemed hostile, but if you review Mr. Rosen's questions, a lot of them were very leading questions, very suggestive as to what he wanted the answer to be or where he was going with the question, where really the only answer was a yes or a no. That's an example of a leading question that you would typically ask in an examination. But here, when you have a hostile witness, you can use that type of questioning technique on direct examination. I think there's some leeway given when, even if a witness is not declared hostile, but you know that the witness's biases may lie with the prosecution or the other side, the judge may give you more flexibility in the manner you ask questions. So Mr. Rosen had a lot of flexibility in the way he asked the questions of the officer, where really the officer's only option was to say either yes or no.
Yeah, you're absolutely.
And it is not atypical.
Yeah, you're absolutely right. And in this instance, it was not a formal declaration of hostile witness. But as you said, I think Judge Fidler, recognizing the relationship, gave Mr. Rosen a great deal of latitude there. And for our viewers, the difference is, direct examination, usual non-leading question is, could you tell us what happened next? The leading question is, isn't it true that this is what happened? Correct? As Mr. Rosen said, he appended correct, I think, to just about every one of his questions afterwards. How about as a prosecutor, though? As a prosecutor, all of a sudden, you've got a friendly witness on the stand, and you can, in fact, then go ahead and cross-examine that witness. Makes it awfully easy for you to conduct that examination.
Absolutely. It's like every question can be loaded with as much good stuff for your side as you would like there to be. I mean, every question can be a home run for you because this witness, number one, you're allowed to ask leading questions now. Number two, this witness is friendly towards you, and the witness is going to do everything he can to help your side. I mean, he is a police officer, and clearly his interests and bias lie with the prosecutor. So, yes, when I was a deputy district attorney, when I had an opportunity to cross-examine a police officer, absolutely, I did everything I can to load my cross-examination with as much as good stuff from my side as I can, so all the officer has to say is yes or no. So it's a very powerful tool for the prosecutors to cross-examine friendly witnesses.